Jiro. I am a human resources professional with a background in law, so this conversation is really exciting for me. I like to navigate between those in between moments, and so this is right in that space for me. Definitely looking to learn more and also refresh some of the things that I also know, and I think it's going to be a really interesting conversation. So I'm your moderator for today, and we will do our best to keep the conversation really practical. We have a lot of things to cover. It's a really broad topic, covering what HR managers and business owners need to know about Canadian employment law. So for some of you, this might not be new information. It might be a refresher, but for some of you, like Vimbaina Shea, or some other people who are transitioning into HR, into Canada, and wanting to know what are some things that you have to keep top of mind for you, this is definitely that conversation for you. So let's get into it. So again, welcome. If you're just joining us, please introduce yourself in the comments and let us know where you are joining us from in the chat. We want to know all of the people that are here and see some of our neighbors or people who are so far away. As we get into it, we are going to talk a little bit about, why we're here, obviously for the webinar, but we want to clarify a few things. So first, some housekeeping. Or, before we get into housekeeping, let's clarify who this webinar is actually for. So, you might be a business owner or a founder and you're looking to protect your company from lawsuits. This definitely is that webinar for you. Like I said, some of you are just maybe transitioning into HR. You want to know more. This again is something that will be very valuable to you. You might be a people manager or a team lead and you want to understand or be more confident in how to manage the employees at your company and how you can be compliant. This is the webinar for you. Again, you're a HR professional, a consultant, or a leader who you want to deepen your knowledge of compliance. You want to reduce some risk and also boost the value that you bring to your organization. Have that seat at the table, be able to have conversations and to be able to steer leadership. This is the webinar for you to attend. And then we have, business leaders who are just wanting to avoid some mistakes. So if you fall into any of these categories, you are definitely in the right place today. So as we've done that, let's get into housekeeping rules. What are some things that we need to know for this conversation to be really effective? Invite you to turn off all distractions so you can really focus and be present in the moment. Take notes. If something comes up and you're really interested, we invite you to take notes as well. And if you have questions, please drop them in the chat box. We have team members who are going to notify us of those questions. And just so we know, this webinar is going to be recorded. I believe that started Imole. If we have a team member who could start that recording, that would be really great. So now, what are some of the outcomes, or what are some things that we're hoping that you will learn from the end of this webinar? We'll get right into it. And so while the intersection between HR and employment law is quite broad, we really want to ground our focus on some of the most common pitfalls that employers or HR professionals unknowingly fall into. What are some of these things? We'll hear from our speakers really soon. They'll tell us some of these areas where we can avoid and how we can be a compliant organization. We're also going to talk a little bit about federal and provincial laws, how they differ, and which ones affect your business. If you've been in Canada long enough, you understand that, provincial laws do differ. And based on the kind of sector or the industry that you are, there might be some nuances or differences in the expectations for employers. So we're going to get into some of that as well today. We're also going to talk about some new regulations and real-world lawsuits that offer valuable lessons. We'll dive into personal experiences of the speakers, and just for us to understand some things that we should keep top of mind or on our radar as we're HR professionals or business owners. We're also going to talk about some workplace policies that every business must have to stay compliant. We will try our best to get into some of these, but as you know, we also are offering a course at the end of this session. We'll talk a little bit more about that. And so some of these things that might not be covered, we will have the opportunity to delve into that at that time. And then last but not the least, we will also talk about some legal and strategic approaches for us to handle terminations. As you know, this is a really tricky subject for some people. So helping us understand being confident and how to stay compliant so we can avoid legal risk is something that we will also talk about. So now, without further ado, we're going to meet our speakers. So we've got Debbie Wilcox. Debbie is an accomplished in-house legal counsel with over 12 years of experience specializing in corporate, commercial law, and energy, oil, and gas law. In her role, she wears many hats and her work spans both across the legal and HR side. But Debbie is also known for her exceptional analytical, strategic, and communication skills. Debbie will provide us some legal guidance from her experience, what she's done with businesses in ensuring compliance, risk mitigation, and also sound decision making. She's a highly efficient and detail-oriented professional, and she thrives in fast-paced environments, offering proactive solutions and independent decision-making capabilities. Debbie, we're really excited to meet you and to learn from you. Welcome. If you could just share maybe like a quick 5, 10 seconds shout out to the team, that would be great.
Yeah, hi everyone. My name is Debbie, and I'm very happy to be here. So Ejiro, thank you very much. Yes, you're correct. Can you guys hear me?
Yes, we can hear you.
I have several years of experience spanning. I do wear a lot of hats, and employment is one of those hats. And I like to say one thing, that employment is one thing that keeps me happy because it's just super interesting. So when the oil and gas world gets boring, I always take joy in running back into employment and HR stuff. So thank you everyone for having me.
That's awesome. Welcome, Debbie. And next we have Imole Ayo Ashogbon, popularly known as Imole and called Coach by so many people. As we can see, Imole is a distinguished figure in the world of human resources. He's known for his unwavering dedication to transforming organizations and empowering professionals to excel in their careers. I like to call him Imole. He's a trusted advisor and a catalyst for growth. He's worked in really great organizations. He's worked with world-class leaders while working for Fortune 500 companies. He has an outstanding career profile that showcases his expertise and passion for HR. This is not on screen, but one thing I would just add, Imola is also a founding partner of one of our largest immigrants HR community here in Canada. I know it's not on the screen, but I wanted to highlight that as well. Welcome, Imola. We're so excited to have you here.
Thank you. Thank you for having me. I'm so glad to be here, and I'm so glad to see everyone. And Debbie, so glad to have you. Debbie's profile is so conservative. She wears, she's so powerful. It's so good to have everyone here. I'm looking forward to these juicy conversations, and looking forward to an exciting and more empowering time today.
Thank you, Mole. Okay, so now that we've introduced the speakers, again, we're really excited to start. I'm hoping everyone is ready. If you are, please drop an emoji in the comment section below just to get us started. I would like to see some emojis, bring some energy to the chat. And also, if you've just joined us, please put into the comment section your name and where you're joining us from today. We want to see where people are joining us, tuning in from today. Thank you. Thank you to everyone who's putting an emoji into the chat. Okay, so let's get started. So I see we're 9 minutes in. We do intend to wrap up by 10:50, so we're going to try our best. It's a really broad topic, like I said today, but just to ground the conversation and for us to focus. Like I said, Canadian employment law is vast. But for us to start, let us start strong. Debbie, Imole, I'm not sure who wants to answer this question first, but I'll just say a lot of HR decisions, in my experience, feel really small in the moment. Sometimes it's a verbal warning that should have, something happens and it's a verbal warning instead of a written warning, or the other way around, right? Or we skip documentation sometimes because someone's already leaving. And these small issues or small moments really lead to the big legal headaches. In your experience, what is one common HR decision that appears really harmless, but has led to numerous lawsuits? In your experience, who wants to go first?
Can I go first? Because
absolutely.
This is a live topic for me. This is something I deal with on a daily basis, and I practically lose my mind. So to give you a bit of a background, I work with one of the biggest companies in Canada. We have over 15,000 employees. So even if 1% of 15,000 people are unhappy, you can imagine the amount of lawsuits that we have to deal with. And oftentimes, as much as HR professionals are fantastic at what they do, they
Mhm.
often overlook the legal implications or the consequences of these actions. So oftentimes legal isn't carried along until there's trouble. And then the file comes and I'm asking questions and I'm going like, what did you do? And one key thing that stands out for me is
Mhm.
documentation. Oh my goodness, I need a paper trail. I need to know. Don't tell me that someone warned him. It's not on the file. Because at the end of the day, when push comes to shove, lawyers are going to argue on
Mhm.
what they prove it. So someone is terminated wrong, the person believes, whether with or without cause, the person believes it's wrongful. Or someone
Mhm.
is terminated without cause and believes it's discrimination for one of the various grounds that we have. And this person comes forward to say, you guys were wrong. And then I'm trying to build a story to say, well, we did everything right. But then I look into the file and things that happened are not recorded. So, and one thing that stands out to me is when we're terminating for performance, this is one of the most difficult things to do in the Canadian employment client because Canadian employment client is pro-employee, it's not
Mhm.
pro-employer.
So true.
Yes.
It's very pro-employee. So it is very difficult to terminate for cause if the reason is performance. It's so hard. So I'm asking, if you're terminating someone for cause because they're not doing what they're supposed to do, I need to see it. I need you to build me the blocks to show you warned him verbally. Did you send an email to capture what you said? You warned him, written. Did you put him on a performance review? Did you follow up with everything in your performance review? I need to be able to justify. So if there's one thing that's taken quite harmlessly, honestly. And when you deal with a lot of people, it's kind of normal that some things will
Mhm.
fall through the cracks. For me, one thing that's most important is documentation. Please document. That's the only way we can defend whatever decision that HR has taken.
Yeah.
Yeah. That is I totally agree with you. And like you said, terminating for cause has such a high threshold, right? And
Mm.
so the courts want to see all of these documentation. So yeah, thank you for sharing that. I hope people are taking note. Imole, what do you want to chime in? What's your experience with
Yeah.
that? And
Yeah. I want to
also,
chime in.
just to add to that, when you respond, maybe tell us one way in your experience that you've seen that we can have a safeguard around this to avoid this kind of situation.
Yeah, awesome. I I'm just smiling because hearing Debola talk, I'm just hearing our lawyers talk, right? You go to them and and she's very correct. And I think I'm going to write on what she said, but just going to add a new twist to it.
Mhm.
Terminating an employee without cause using outdated or vague employment contracts, right? That's something that I have seen, right?
Mhm.
When you sometimes, because you still have to follow the statutory minimums under every professional employment standards, right? And
Yes.
of course, it may trigger common law reasonable notice obligation, which can be
Mhm.
significantly higher. So you see that many employers sometimes we rely on poorly drafted contracts,
Mhm.
and you find that sometimes it leads into trouble, right? Because truth about it is I've seen that happen I've seen a lot of termination without cause, because you think it's without cause and because you said the person has not done anything and they can go, but you're still violating something. So my own angle to it, in some of the instances I've seen, and even some of the clients I work with, and that's why I was brought in, is, of course, organizations must constantly engage in annual contract audits, right? By legal counsel, not just HR. There are language in
Yeah.
HR, there are language in contracts that those language, when an arbitrator dissect it or when the union dissect it, you'll be blown away. It's not just black and white. And for me, one of the things I did to reduce it when I was still in paid employment is to really train leaders. Of course, train HR leaders, but train managers and train leaders so that they can flag those risky clauses and never assume that statutory pay is sufficient without a legal review, right? So if you want to use termination clause, you can't just use templates just like that.
Mhm.
It has to be proven specific. It has to be court tested. It has to go through all of that and get your lawyer involved early. If you don't have a lawyer, make sure you're sound in the interpretation and in the context of it. You can terminate without cause, but meanwhile, there's the person has made an allegation of harassment before now. You guys have done nothing, and you think it will go away like that. I mean, sometimes multi-layered,
Hmm.
but if you follow this, sometimes it get easier.
That is really interesting that you say that.
Mm,
Imole, I'm curious, in your experience, would
mm.
you say that this is something that happens more, maybe in a unionized environment or non-unionized environment, or is it something that typically happens in a smaller company versus a bigger company? What's
Uh,
been your experience with this?
That's that's a fantastic question. When I was work with Coke and other organizations, I thought it was more predominant amongst big organizations. Like Debbie said, I mean, if you have 1% having issues of fifteen
Hmm.
thousand, that's huge. Coca-Cola we're up to 10,000, that's huge. But I found out that in small and medium scale businesses it is more predominant. So
Okay.
last year, Canada, there was a $1.2 billion payout, across board due to wrongful terminations, rootful, lawyer fee, and all of that, all within the SME, all within the SME with less than 100 employees in Canada. That was what the data said. So you find that it's not just the big companies. In fact, it's almost more predominant. I did a comparative analysis, but if there was a 1.2 documented $1.2 billion that was paid out to fees and all of that due to wrongful termination, discrimination, and all of that, that tells you that is a predominant around amongst SMEs because most of them don't have solid HR, nor do
Mhm.
they have solid guidance to mitigate against things like this.
That data is staggering, Imole.
Yeah,
Wow.
yeah.
Okay, well, as we go on, like I said earlier, if people have questions, please put them into the chat box. And if you also have insights that you want to learn to this conversation, we invite you to also include that as well. So thank you so much, Debbie and Imole, for answering that question. Let's move on to the next one. Um, this question is really interesting for me, and let's talk about mindset here for a minute. In HR, we often prepare for the eventuality of a lawsuit. Like Debbie had mentioned earlier, talking about documentation, those things are really important. Someday we know we have to tender some of these conversations or emails as evidence, right? In this, having this kind of mindset, do you think that employers or HR professionals should have a termination process in the organization designed to be lawsuit ready, or is this a wrong mindset? Does it reflect a fundamentally weak system? What's your perspective on this?
I think that we should hit that first.
Yeah, sure, Debbie, go for it.
I think you're calling the wrong person first, and the reason is
Okay.
because I am going to be biased.
Oh,
I
okay.
am a lawyer, so you can expect what I am. You can expect what I'm
Okay.
going to say.
I love
Yeah,
that. So let me go first then.
yeah.
So this is how I say it. Lawsuit
Mm-hmm.
ready. This is the first fundamental thing. Once you're into people's business, you are potentially into legal business, right? And I mean, sorry to say, we're not from. This is Canada. This is not like some countries where some of us come from, where we're not lawyer trigger ready. You know what I mean?
Yeah.
Countries like Canada, come on. And most times you find that people that are not lawyer trigger ready are immigrants, because
Mm.
you're still on learning and all of that. But the average
True.
Canadian is lawyer trigger ready. It's not America. So in a Canadian lens, designing termination to be lawsuit ready is not a sign of weakness. It's a compliance imperative, right? I mean,
Okay.
and in a legally sophisticated environment in Canada, that is it. So employers typically will face risk not only from wrongful dismissal claims, but even human rights complaints. I get in it. Human rights complaint, constructive dismissal is there, occupational health and hazard is there.
Mm-hmm.
So it is there. And in 2023, you can check this up. Canadian HR reported that 47% of legal actions related to employment was about termination event itself. Was not about termination event itself, but how the termination was handled, particularly lack of due process, documentation, or even psychological safety. So you got to be ready. Either you like it or yes. And you as a professional, you as a business owner, in the law, excuse is not ignorance is not an excuse. So I
For
think I will
sure.
stop there so that we hear Debbie's
No,
angle. But
that is really great. Like I find that really insightful. So it's not like you said something earlier. You said it's a business imperative to be ready, lawsuit ready. You're not operating from a place of fear or just from values. You're thinking about what are some of the risks that your organization can face, and so you have to be ready for that. Debbie, do you want to chime in? What's your perspective on this?
Yes, Being a lawyer myself, it's very simple. Please be lawsuit ready. I can tell you that the most innocent of decisions that you take, you will be amazed at how the next person will take it. And Imola, I totally agree with you. And I'll give you a real life example. In a situation where we all know how COVID-19 went down, right? And we all know how many lawsuits have arisen out of that. I am currently dealing with over 100 lawsuits filed by employees, over 100 lawsuits filed.
Wow.
Six
And they're all
lawsuits alone.
active files.
Active, over 100 active COVID-19 files. And not a single one of those was filed by an immigrant. All of those files, every single one of them was filed by Canadians. So the point is, this is a climb. This is an environment where they are lawyer triggered.
Yeah.
Even for the most mundane of stuff, you would hear, I will be calling my lawyer. You'll be doing a disservice to yourself if everything you do, you don't do it with, if this turns into a lawsuit, where do I stand kind of mindset. You will be shortchanging yourself.
100%.
That is a
That's a
really
lawyer.
interesting,
That's a lawyer.
really, really interesting perspective. And I find, Imole, like, just in my work as a HR professional, I'm sure, this resonates with other people. Sometimes you prepare for terminations and you think you have a script, right? But things happen in real life. Things happen. People have emotions. Things feel rushed sometimes. Sometimes things are inconsistent, right? And sometimes that's where the lawsuit starts to creep in. So I think what you guys have shared is really, really important. Really puts this top of mind for people. It's like, hey, every single action that, every single action can result into a lawsuit. So are you ready? Are you proofing your systems or your processes to ensure that it's lawsuit ready? And so this brings me to like another question, a bonus question I would add. In your experience, what is something that really signals to an employer, to an HR professional that their process is in lawsuit ready? Just want you to touch on that really quickly. Imola,
Sorry.
if you can take this question. Yeah, I'm
Yes,
saying
sorry.
what is something, yes, what is
Yeah, go
something.
ahead.
Yeah. So based on the conversation we've just had now, what is something
Mm.
that you think signals to an employer or can signal to an HR professional that their process is not lawsuit ready?
Oh wow, that's broad actually. That can be broad, but what can signal that is not ready? I think I'll take it on the reverse. If you're an HR professional, that's why I tell people, I still put on LinkedIn just this week. HR is one of the most difficult and most complex jobs. If you're an HR professional, you're dealing with life processes, you're dealing with people, you're dealing with organizations, you're dealing with destinies, if I can put it that way. So it is imperative that you constantly check. You can't be an HR person and not be constantly checking the updates on the law. You can't be an HR person and not be active in environments where they share insights, where you see updates. You can't be an HR person and not be in an environment like our group that you talked about. That's why I started the group, so that people can be in those environments and know what is happening. You can't be an HR person and not keep updating yourself, because the law changes. And like I said, ignorance is not an excuse. So it is broad. It is broad to say that you're not ready. No, it is. And maybe another key pointer is look at the data. What is the termination rate? I might not look at that from that angle, but you can look at what is the grievance. If you're in a unionized environment, what is the grievance data saying? If you're terminated, you make termination and there's always a backfiring, what does that look like? What does the data say? And then you look at your your policies and all of that. Are they generic, right? What made you know that these are updated and they are best practice and they are compliant and those clauses are in alignment? So it's quite broad, but it's a continuum. You know what I'm saying?
Yeah.
And
Okay.
you have to engage on it on a regular basis. But look at the data. How much grievances are you having? How much problems? How much complaints are you having? Even if you're not
Sure.
unionized, that's
Yeah.
the pointer.
Okay. So go back to the data. Thank you very much. Okay.
Mhm.
So our next question. What is a common oversight in employment contracts or workplace policies that employers frequently miss in your experience? What is something that you've seen? Debbie, do you want to go?
Yes, can you hear me? Yes. Like Mole pointed out earlier, for me, the two things stand out in employment contracts. One of them is the key thing, termination. how strong is your termination clause? What does your termination clause say? Knowing that the employment standards is on the one side, common law reasonable notice is on the other side, and that the position that the courts have taken in several cases without ending, right now the Supreme Court decision that is currently in place is the Matthews decision, where the courts have said that for an employment clause to be effective, it has to be drafted in such a way that it is clear and unequivocal to the employee at the time of signing that employment contract that this employment clause is intended to deprive the employee of their reasonable notice. So oftentimes what happens is that we draft termination clauses in a way that it will not withstand scrutiny in court. Even though we say you are only entitled to the employment standards code, the court is going to say that's not enough to make an employee know that you don't intend to pay reasonable notice. Another thing that employers they're not alive to, and I want to bring up, and Imola, I think you mentioned it earlier, auditing your employment contract is something in law that we call the doctrine of subtraction. Now, that's big English that simply means when you employ someone, for example, as an admin assistant, and after 2 years, you make her a payroll assistant, and after 6 months, she becomes the collections agent, you need to change your employment contract. That employment contract that bound her when she came in 4 years ago or 5 years ago in a different role, but you have subsequently changed her role, substantially changed her role over the years, she will need, or he or she will need to have another employment agreement in place, because the roles have so changed that the court is going to hold that she is no longer bound by that employment agreement from years ago. And employers do not know that. So when you end up terminating the person after 5, 6, 7 years, and then you're relying on an employment agreement from 7 years ago when her role has changed 5 times, the court says, no, that agreement is no longer valid. And then you find yourself on the hook for everything else that you thought you were, in quote, protected from in your employment agreement.
That is great. A really great insight. So what I've heard you say is every time someone moves into a new role, that's a trigger for a new updated contract.
That's
And I
right.
think that's you had mentioned, you said it's the doctrine of subtraction. Was that what you said?
The doctrine of subtraction, yes.
Okay, no, that is very good. Thank you for sharing that insight. And like Imola said, like very most often people in roles, HR professionals, you inherit these contracts, you inherit employee handbooks, you inherit policies that are not quite updated, right? So making sure that we find time to audit these things, make sure there's a lawyer who's reviewing our policies or our employment agreements just to ensure it's updated and it's in line with what's happening, the shift that's happening outside the industry or in the legal world is also really important. So thank you for highlighting that for us. So let's go to our next question. I see that we're almost at 10:30. So we'll just move really quickly. This one is a little bit tricky for, I find that, as HR professionals or even business owners, sometimes you feel stuck in the middle. Something is being said, there's on the legal side, on the culture side, and also wanting to ensure fairness. In your experience, have you seen that kind of conflict? Where are some places or some situations you've seen that kind of conflict? And how do you decide what matters most? What should take precedence?
Hmm. So shall I go for this?
Sure.
I should go. I should go ahead, right? Should I?
Yes.
Okay. So you need to look at this as, I'm going to balance this with Canadian perspective here. Number
For
one,
sure.
legal compliance is not negotiable in Canada. Do you understand? What
Mhm.
it does is that it forms the minimum threshold of employers' behavior. And like Debola said in the beginning, the burden of proof or the law favors employees more than the employer. So we need to have that established. So, you can't negotiate that. So think about an employee's legal action. So if an employee's action legally qualifies for dismissal, but firing them will conflict with your company's, like restorative culture or violates the psychological safety protocols, the solution is not an either or a yes or, right? You can pursue the legal compliance while you are integrating the fair processes. Are you getting what I'm saying? But sometimes you cannot just fire them like that. I've been in that situation where an employee, we had a meeting with an employee. In that meeting, they were very forceful, they were violent. Now, I'm going to describe exactly what they did. In that meeting, and it was a violation of our policy, they banged the table. Then they tore our shirts. They tore the shirts that had our logo on it. Look at them, like Debbie opened them up. They tore it and they stormed out. I was in that meeting. And that was a very good ground to terminate, dismiss this person. But because they stormed, but what happened? What happened in this situation? Number one, we knew that this person had mental health issues, right? We knew that they had a case. Do you understand? An existing case. We had medical records that they were going through treatment, but they were cleared to return to work at that time. And so, unfortunately for us, we didn't have enough to terminate. We couldn't even terminate. In fact, immediately I told the supervisor and the manager that we need to go and check this person because we also have the duty of care, right?
Yes.
Because I had the information. I knew their pre-existing conditions. So I can't just say what the hell. And I had to make sure that I called the union. They called to know where they were. In fact, I immediately told them I was ready to get an Uber, right? Because we had the duty of care. Because if anything happens to them while they were going home or on the way, that might be another trouble for us. Yet, what they did was dismissible, but we did not. So you see, there has to be a there has to be a balance between your legal compliance or your organization, whatever that looks like. There's always context. Are you getting what I'm saying? Because, for instance, I know that the Ontario Human Rights clearly, and even BC Human Rights, encourage what we call procedural duty to accommodate, and that was what we did in that situation. So that's why you have to balance it. You have to balance compliance with culture, with context, with human rights. You can't just blow black and white. That's why if you have to be an HR person in Canada or you have to run a business in Canada, you have to know all of these things and know how to interpret it contextually while protecting the employee and the employer.
That is really important insight, Imole. Thank you for sharing that. I find, there's not everything is black and white. There are
No.
some grays that you have to navigate. And just because, there's a law that something's there, sometimes you do have that duty to inquire, that duty of care, needing to understand what's happening. What are some historical contexts here? What are some things that you can do to support? It's not always just the easiest route to just say, hey, let's terminate this person. There might be a backstory. And I think just understanding that brings in the human element. That's human in human resources. So thank you for sharing that. I'm so curious to hear what Debbie says, if she has a different perspective from you as a HR professional. Debbie, please.
Actually, I just want to build on what Simole just said. And you just mentioned something I was about to say, which is the duty to inquire. I am, as a lawyer, I am actually more worried if I have a lawsuit, if I have a case brought to me, brand new case. My first question is always, do we have HR? Are we at risk with human resource with human rights? I am more worried about the human right than I am about the civil court. Because at the end of the day, in court, it's a game of numbers. How long did you work for? Battle factors. Let's calculate how much your. But I am a lot more worried about human rights because human rights they have far-reaching powers. They can ask me to reinstate. They can ask me to pay back wages and lost wages. They can give me aggravated punitive damages that I don't want to deal with. And one of the issues you just mentioned is the duty to inquire. So that situation that Imole just explained, for example, if you look at it strictly from the legal sense, you want to say, yes, get out, you're done.
Yes.
But however, we have the duty to accommodate. And according to the human rights legislations, in every province, we have a duty to accommodate up until the point of unreasonable hardship. That is a point that is very, very difficult to prove. How do you prove it's unreasonable hardship? It's easier for small 1-man, 2-man, 3-man businesses to prove unreasonable hardship than it is for 10, 15, 20 employees plus to prove. So this guy who has a mental problem and had done stuff that is worthy on paper of termination, if you had gone ahead to terminate him, you're looking straight down the barrels of discrimination on the basis of mental disability straight up, and you are guilty. So you simply cannot take the action alone by itself. Even if, and another thing is, I've had an employee come to work and misbehave, and HR came and said, we will terminate it. And I said, no, but he has 25 years of employment with a absolutely clean slate. This is the first time in over 20 years that he's doing something that is so obviously wrong. You have the duty to call him and ask if something is going on. Turns out the guy had lost a child. He was going through depression and then he began to do drugs. I'm like, so you don't terminate. He goes on short-term disability. He goes on long-term disability. He goes to rehab. You have a duty to inquire. You have a duty to accommodate. If we had terminated that guy without making those inquiries to find out, we would have been the ones that were wrong.
Say that again.
Yeah, that is it's no, that's a thank you for sharing that information. I'm sure there are people here who are thinking and they have a lot of things on their minds. You know, they want to go back to work and they want to make sure that these processes are in place so they can avoid legal risk. Thank you so much, Debbie. That's really insightful. So now let's go to our next question. And we're almost getting to the end here. But I'll say, Debbie, maybe take this one first. You know, let's look a little ahead. There's so many shifts happening. You talked about, you know, the cases that you're currently working on. There's so many things happening. There are bills, there are laws being passed about, you know, pay transparency, hybrid work, and even more recently, we have AI now in the workplace. What are some legal trends that you're seeing, or some court decisions that you've seen so far that you think we should, that is kind of flying under the radar that you think HR professionals or business owners need to be aware of?
So there's quite a few that's been going on of recent. And one of them that I find interesting in my world, or two of them that I find interesting in my world, is just as of January of last year, I live in Alberta, so the courts in Alberta have now passed what we call the streamlined trials. We didn't have that in place before. And that doesn't look good on the employer because it allows the employees who are wronged to have a shortened access to the court system. What usually deters most employees from, going after these cases and making this, because it takes, the legal process it's time consuming, it's very expensive. So the courts have created what they call a streamlined trial, where you don't have to do a full-on trial. So it's not as expensive as a trial. It doesn't take as much time as a trial. It gives the employees a faster, cheaper, easier access to the courts and to recourse at the courts. That puts an employer under more pressure, because what that means is people who otherwise would have just turned away and left because they didn't want to have to deal with the rigors of going to court now have an opportunity to take that on and do go to court, because the courts have created. And then the the Alberta legal profession actually came out with a guideline for the streamlined process, and they unfortunately clearly mentioned that employer-employee disputes is whether with cause, whether without cause, is one that clearly fits into one of the processes that should be handled by the streamlined trials. So what that means is that we have seen a lot more people who otherwise wouldn't have taken their matters up to court now doing so because of this new process.
Yeah, they can get judgments quicker, right?
Yes.
Imola, do you want to chime in on that? What's
Yeah.
in your experience? What have you seen?
Yes, because I'm going to mention three quickly, and because I dealt with one a lot in the activeness of it. That's when COVID happened. I'm going to talk about that, but I'm going to talk about constructive dismissal and remote work madness. Right?
Okay.
I said madness, mandate. Remote work madness. So courts are now really scrutinizing employers that force the employees back to the office without proper policy changes or mutual agreements. Right? There was a recent case in Alberta that they ruled that a unilateral return to office requirements, may constitute constructive dismissal. Are you getting it? If it's not aligned with prior arrangements. And you know what that means? You and I have agreed that you work from home, right? And you just come unilaterally, more like you have to resume work by Monday, right? And you didn't remember to even change your policy and all of that. So that's a trend that organizations and HR professionals need to look at. There's psychological health as a legal obligation, right? So there's a rise, and I'm sure you've been seeing it on LinkedIn. There's a rise of toxic workplace lawsuits and mental health accommodation cases. Are you getting it? Yes, there's a rise of it. You see a lot of in BC and in Ontario, there's a significant mention of claims that arise from bullying and burnout, and there was a lot of data to support it. So that's another trend. And then there was I saw this recently. It has to do with AI and recruitment. And right? You saw that too.
Yeah.
Okay. So here, I mean, is under a lot of scrutiny. So whatever tech organizations are using right now, they need to be transparent, explainable, and it must pass the bias test. right? So
Absolutely.
that's something critical. And I'm sure everybody knows that every HR person knows there's about the Bill C65, right? And Bill C65 is something that is not going to the impact of it is not going to go away, but it's coming more into visibility here. And that is mandatory harassment and violence prevention policy for all
Mhm.
federally regulated employers,
Business.
right? And of course, it has an implication for HR professionals and of course businesses. So you see those are some of the trends that I've seen that is really coming up and
Yeah.
we must pay attention to.
Yeah, no, thank you. Definitely things to stay on top of mind and be keep abreast of these changes for your organization. So thank you for sharing that. Last but not the least, if we were to build a lawsuit-proof organization today, what are the top three measures that you would advise that we implement immediately? Or maybe even what's one simple but impactful thing that we could start and take away from today's conversation?
Uh, I is it possible to build a lawsuit-proof organization? I do not think so. But is
Okay.
it possible to make your organization as strong as you can to withstand lawsuits better than we currently have right now? The answer is yes. And one of them is, please, when you're drafting employment contracts, please do not do it by yourself. Get legal advice. Get an employment lawyer to look into it. Because at the end of the day, what determines the relationship between an employee and an employer is that employment agreement. It's the most
Okay.
important. It's like a marriage certificate between a couple. That's what your employment agreement is. So when you're drafting an employment agreement, please get legal to look into it. Get a lawyer to draft it. And another thing is what most people are not aware of is like one thing that you mentioned, Emma, that I'm very happy that it's coming to light now is constructive dismissal. A lot of employers do not understand constructive dismissal, do not understand what triggers constructive dismissal, and really, really how easy it is to trigger constructive dismissal. So if you're making changes to unemployment, if you're making changes to a job description, if you're making changes to schedules, shifts, hours, wages, be able to draw the line in which what is an employer allowed legally to do and what would constitute constructive dismissal is very important to be able to foolproof your organization. And lastly is another thing that we tend not to look into as much, which is looking into the idea of bullying and harassment. It is so, so important. And a lot of us, and one thing that I've realized is that because of where we come from and who we are, a lot of things that we take as normal
True.
constitutes harassment. So if you're a small business owner, if you're an immigrant who owns a business, I beg of you, retrain your mind to understand what constitutes harassment in the Canadian workplace.
Mhm.
What we would have done in other places, in other clients that would have been totally normal and nobody bat an eyelid will be a problem here.
True.
And that's one thing that a lot of people, and I've seen this with small business owners, you have 5 employees, you have 6 employees, you come in and you think you're joking. You're not joking. Somebody will take offense. And you're wondering, but what did I say? I was just, no. So we need to be very careful when it comes to bullying
Yeah.
and harassment and understanding what constitutes harassment and what constitutes bullying. Because it's not until you slap someone that you have bullied them, especially in the workplace.
Thanks, Debbie. Definitely a lot of unlearning and relearning to do. Imole, we're almost out of time, but if you could just quickly chime in so we can wrap this section up.
Yeah. I mean, I think Debbie has really touched on the very key part. The part I will talk about is training, managerial training on legal aspects that has to do with people management. You can't overemphasize it. Are you getting what I'm saying? I mean, when you find that 68% of terminations that led to lawsuits, they were from frontline managers' error, right? Or the fact that they didn't execute a policy very well. That is a huge thing you must focus on. So what I'll add to this is training. You can assume, you can't come with your previous knowledge. You can't even be emotional about it, right? So you have to train on progressive discipline. You have to train on duty to accommodate. You have to understand documentation. You have to even understand what to say during termination. During termination, there wasn't a termination. I had to stop the manager. I'm sorry, please, we need to stop this right now. And that was what savaged the situation. The guy was going on a tangent. He would have put us in big trouble. You know what I mean? So the truth about it is, I say the training is critical, and of course we will talk about it here, but it's something that can help you future proof or lawsuit proof to a level. Then the
Mhm.
other thing I'll say is you need to build in risk, what I call risk flag systems into your HR, where it can be flagged before it becomes an issue. So you want to check patterns and complaints, you want to check absenteeism, you want to look at leadership gaps, you want to look at your leadership, your people's leadership style. Debbie talked about bullying and harassment and complaint and all of those toxic things. The truth about it is there has to be an indicator, all right, for you to know that this is happening. You need to pay attention to it, you know. And then if you don't have too much money, or it depends on your size, you still need to have a legal risk review committee, right? High impact HR decisions that you're going to make, don't make it on your own. One of my clients, I told, he was like, Imole, this is what I want to do. I said, oh God, calm down. I literally told him that. I said, you need to calm down. I hear you, I feel you. You need to take a break, take coffee, come back to this, because the way you're feeling, I know what we to turn that to, and you know that saved the day. So excuse. Oh, sorry, there's something on my mind. Part of it is also to embed a speak up culture, right? And the grievance resolution process into your business. If you're a business owner, if you're an HR professional, you need to have that skill to see how you want to imbibe that into your system, and maybe your legal issues will be reduced.
Well, thank you so much. All great insights. I know we're almost at time, but I'm going to crave the indulgence of all our participants to maybe allow for another 5 to 7 minutes if we can. I do want to allow for questions, but I'm thinking we go ahead to talk a little bit about the course first and then maybe take questions after. For maybe anyone who has questions, they can stay behind, just so we're respectful of time. So, Imole, can we just get into the course? We've learned so much today. We are so grateful for all of the insights that Debbie and yourself have provided. But I know that there's a course, right? There's an employment and compliance law certificate course. What can we learn from this course? Who are the people that you're looking to have attend this program? And what are some things that they can find valuable in this program if they're to attend?
Beautiful. We have 13 minutes more, so I'll just quickly go through it and then we can ask questions. So at the end of the day, all of these are competences, and I was looking at it from two lenses. And if you're an employer or if you're an HR professional or you want to come into HR, if you don't understand employment law in Canada, you're a joker. Are you getting what I'm saying? And so this course is an employment and compliance law certificate course, right? And in that course, everybody that attends would have opportunity to, please move to the next screen. We'll have opportunity to understand, you have a position to understand the basics of employment law in Canada, the employees' rights. They need to know how to hire, how to terminate. They will learn how to create policies, contracts, and handbooks that complies with the law. It's also in this course they also learn how to handle workplace disputes, complaint terminations without legal issues or with reduced legal issues, right? Because if you're also an HR professional and you're always making your company pay too much, with due respect to Debbie, you're always making your company pay too much legal fee, you're not effective and efficient, then we don't really need you. So in this case, you understand the legal aspect of remote work, how to strengthen your HR compliance knowledge, and of course, at the end of the day, for those who want to transition or even want to strengthen their current place, what we do in HR is to put a system process in place so that the organization will win in the marketplace. At the second level, what we do is to protect the organization. We are risk indicators, we are risk mitigators as HR professionals. And so this course will train you to understand all of these, and is no fluff, is practical. I mean, you've seen from the quality of what we've gotten from these conversations, right? I mean, you're going to get deep practical insight if you attend this course. More importantly, you also get CPD hours, right? Luminous is a CPD approved organization, and so if you're an HR professional or even if you're transitioning April, you have your CPD hours to do your continuous process. You can also go forward. You also, if you do this course, you also get a certificate from Luminous, and then you can put it online. You also get a badge. You also get a badge. This is for our advanced labor relations. You also get a badge like this that you can put on LinkedIn. And this strengthens you. You get in front of an employer, you get in front of your manager, you're speaking, they know you're speaking from an insightful place. You get in front of your lawyer, you want to go and speak something, and your lawyer is not feeling, why is this person, excuse me, no disrespect, this person is foolish, because the lawyer has told me that. How can she be, and it's your HR, how can he be talking
How
like,
rude.
right? So you go there and you're speaking from an informed place. If you take this course, this is also part of our advanced labor relations course, which is another course we offer. We'll tell you about that later, not in this circle. But let's go. You can go forward a bit and see some of the testimonials of the courses that people have taken from Luminous, and of course, it was from high demand that we decided to take this course. And if you are here, you are transitioning to HR, or you're looking for an HR job, I've not found this an HR job, maybe if you're attending interviews or not, you need to take this course. You need to take the course, because see, HR again is about language. It's a continuous learning, but you need to take the course so that you will speak the night. Whatever country we're coming from, the context here, I mean, Canada is different. The labor laws is different. So many things is different. Right? While your competencies are global, as I tell people, what is different is the culture and the context. And if you take this course, it transforms your trajectory and helps you get a job, helps you get something solid. So move forward a bit. And because, we were going to sell it for $5,000, move forward a bit, but we are not selling it for $5,000. Sorry. So hold on here. Go back a bit. One step back. The course is starting on April 19th. That is this Saturday. Next week Saturday, and it's going to be for 2 weeks. It's going to be on the weekend. It's 100% online class. And go to the next slide. It's going to be interactive networking and all of that. And we're giving this course for as low as $297. That's what we're giving class. That simply means you're not buying 2 clothes. Depends on the kind of clothes you buy, right? That simply means that you take a pause on something. It depends on whatever that looks like. But we're keeping it at this price just to help, either we like it or yes, our immigrants, right? And I've made too much investment in education, and I see it. And you can't just come from a place of assumptions. You have to come from a place of informed knowledge about how things is done here. And this is a simple killer price. It's just $297. And we're doing a bonus for the first 20 people to sign up. You're going to get a free one-on-one compliance consultation, and that can be anything for you, right? Putting you in the right path, helping you navigate, and helping you manage the nuances in the Canadian context, or even helping you in your next level job search, whatever that looks like. So this is the code. You can scan the QR code right now. You can scan this QR code, you can copy it and register for the cost. If you invest in yourself, you see the difference, because you have context, you have knowledge, and you're standing in front of anybody that needs to hear you. They know you know what you're saying. They are not afraid that you put them in trouble. Neither are they afraid that you're not able to help them manage their people issues. Like you've heard, Canada is trigger ready, is lawyer ready, is sue ready. And if you are not strengthened by real life experiences and by dimensions, you'll be in a weak place. So that is that about the course. The first
Thanks,
20
Imole.
will get some extra benefits, and that's it.
Thanks, Imole. Definitely encourage those people who are interested in, like you said, if you want to learn the Canadian system, this is a good course to take. Definitely high return on investment. Navigating Canadian employment laws are really different if you're moving from, maybe coming from Africa or somewhere else. Really understanding, like Debbie said earlier, there's that unlearning and relearning. It's really important. So if you want to have more knowledge and feel confident, definitely something that you should check out. So now, thank you for providing us this information, Imole. I want to give an opportunity to those people who might have questions. For some reason, I was under the impression that we had to finish at 10:50 on the dot, and so that's why I moved the question. I see we're here till 11 a.m. So we do have an opportunity for those who have questions.
Sorry, Joe. Yeah, we're here till
Yeah.
11, and respectfully, anybody wants to stay, maybe they have an important question.
Okay.
If Debbie will stay, we have to get her permission. But anybody has very important question can stay and ask. But why officially we are ending for 11. Please go ahead.
Okay. Well, thank you to everyone who's joined us and stayed on so far. Really appreciate your being present here. And so we're going to open this up to those who have questions. If you have any questions, please put your hands up, or if you have it in the chat, just let me know. I think we have some team members who can pull some questions for us, and we'll just see if anyone wants to go off mute to ask a question. Okay, I'm gonna read through the chat box. I think someone just raised their hands. Yes, Austin, please. If you can just ask your question really quickly, since we're kind of almost out of time, that would be appreciated.
Well, thank you. Quick one. I just wanted to get a better context about how um, this employment law works with probationary periods, because that has come up a lot of times, and I'm really trying to get it because I get a sense from most of the feedback I get that, when people are on probation, they virtually have no rights. So can you please clarify that? Thank you.
Should I go for that? They have so so very quickly. You must understand that Canada is so we have federal regulated organizations, and then we have provincial. Every province has different mandates. They have different laws as regards that. There's some provinces that is 6 months provisions. There's some provinces 2 months. Some is 3 months. Some is 1 month. So first things first, we must know what the province say. Well, so basically, this is what probationary period means. It's a window that allows the employer to objectively, humanly, right, productively evaluate you and see if you'll be a good fit for them, right? And so within that period, they should be able to support you, train you, and allow and check if you're going to be a good fit. And technically, they're allowed to let you go without cost at the end of your before your end of your provision if you do not meet certain requirements. However, within that period, there are certain things they're not protected from. Your human rights cannot be violated. I get what I'm saying. And so even if you're a probationary employee, if certain things go wrong, the fact that you're probationary, they still don't have the right to just let you go. I mean, the 5 protected classes and dimensions, you still must be protected within your probation period. You get what I'm saying? I've been in situations where I could not allow us to terminate somebody within probation because there were serious allegations against the supervisor, and I saw some valuable things in those allegations. And if we let him go within that probation and not address the issue, there was going to be issue. That's why sometimes organizations can extend probation with due course, right, and extend it and come up with something solid. But all of this depends on a whole lot of context and situation that varies.
Imane, thank you. I would just add, like you mentioned, extending probation, and something sometimes people don't realize is that when you extend probationary period and you terminate that employee, they're entitled to receive, notice as well. Some people just think because it's probation, they're not going to have to pay anything. That is so wrong. So something to keep top of mind for you, if you're going to extend someone's probation to 4 months, 5 months, once he passes that 3 month threshold, you're entitled to providing them minimum notice. So just so you know. Any other questions? Ebele Afubero, you have your hands up, so please quickly ask your question. And just before Ebele goes, thank you again to everyone who stayed on so far. We thank you and appreciate your time. We will be wrapping this up at 11 a.m. But like Imole said, if you want to stay on and have more questions, please feel free to stick around with us. We will answer those questions as much as we can. But we also understand if you have to drop off at 11 a.m. So Ebele, you can go on. Ebele or maybe Oludare, Victoria, you have your hands up. One of you can go. Okay.
Okay.
Okay. Let's see if we have any other questions in the chat box.
Okay. If
Ebele, you can go off mute and ask your question. Okay. Seems like Ebele is not there. Does anyone else have questions?
Yes, I do.
Okay, please
Can
go on.
you hear me?
Yes.
Okay, so I want to ask a sort of question. I'm
Mhm.
coming from the perspective of an employee because I am one. So I want to ask that is it reasonable to let an employee go because they are not meeting a set KPI? So you place situations to make the person go through some emotional damages so that they can have mental health issues, and then you let them go on that note. Is it possible to let someone go because they are not meeting their KPIs?
Debbie, you want to go for
Legally
this?
possible. Is it legal?
Yes, I will start on that one. And when you say KPI, correct me if I'm wrong, you mean your key performance index. So basically, you're not meeting your job description as you expected to. You've had a few reviews, and every time you've had a review, there's a problem because you've not met what they expect of you. Is it possible to let someone go on that note? The short answer is yes. Is it easy to let someone go on that note? The short answer is no. But is it possible? So I'll tell you what happens practically. When someone has not been meeting expectation, you simply cannot wake up one morning and say, "Oh, you haven't met your expectations." And which was when when we started this class, I said one of the most difficult things to terminate someone for, if you are using cause, is performance.
Yeah.
Because you have to prove that you let the person know that there was a problem with their performance. Letting them know that their performance is a problem is not enough. What have you done to try to help them get better? So the employer has to show that I let them know I did a performance review, the performance wasn't up to par. We put systems in place. We had coaching, we had shadowing, we did a lot of things to try to make the employee get better, and that did not work. We still let the employee know again that the performance was still, below what the expectation. So you have to build blocks. It's not something that happens in a month or 2 months or 3 months and you let the person go. So what most employers will do, if they are smart and they really do not believe that they can get what they want out of that employee, is to proceed with termination without cause. Because to make out a cause termination, because what the difference between a cause and a without cause, that you pay severance in one and you don't pay severance in the other, that's the difference. So if you're going to let somebody go without paying them severance and performance is the issue, can that happen? Yes. But is it easy to do? The answer is no, because you need to be able to prove that you tried to get the employee to improve and you put systems in place to encourage the employee and the employee still did not improve. That's the reason why you're letting them go. And that's a very, very steep hill to climb.
Thank you. Thank you so much, Debbie. Thank you for answering that question. Really, again, just want to thank you so much for your time, Debbie. Again, I understand that we're at fast 11. Oludare, if you can put yourself on mute, please. So I want to thank you so much for all of the insight that you've provided. Really interesting, really knowledgeable, and informative. From the comments we can see people thought that the insights was really great. Is there a way that we can maybe connect with you on LinkedIn? Is that something that you can provide for people who might be wanting to reach out to you for your professional expertise, or just to follow up with conversations today? Do you have a LinkedIn profile that we can connect with you if
Oh,
you're
yeah, I
open to
do.
that?
I
Okay.
do. I do. And the LinkedIn profile it's my name. It's Debbie Wilcox. Now, I will state this because even though I'm a lawyer and I work in-house and
Mm-hmm.
I do employment law, I do have a lot of experience, but I cannot give you legal advice because I work in-house. But if
Yeah.
you have a personal question that you want an answer to off the record, not legal, because I can't give you legal advice because I'm not covered by indemnity. I can only work legally for my
Yeah.
organization. I'll be very happy. I saw a question in the chat that just came in. Somebody said something about job abandonment. Now, job abandonment is not easy to proceed with termination on. It has to be clear, equivocal, written that the employee intends to abandon. That they didn't come to work 1 day, 2 days. You call them, they didn't pick up their phone, is not enough for you to reach the threshold for job abandonment. It has to be clear and unequivocal that this employee has abandoned their employment and is not intending to return before
Mm.
you can do anything on job abandonment. I just saw that come up and I wanted to answer it. But so,
Oh,
yes, I'm on LinkedIn. It's my name. If you want to ask a question, please go ahead.
Awesome.
yeah.
Well, Debbie, thank you so much. If you have some time and you want to stay on to answer questions, we definitely welcome you to do that. But I also understand, obviously, we did have up to 11 a.m. So if you want to step out, totally okay. We understand and we appreciate your time. But just let me know if you'd like to stay on so we can have a few more questions come your
Let,
way.
I have exactly 5 more minutes, so I
Eh,
can
eh,
Okay.
end in the next 5 minutes before I have
Okay.
to leave.
exactly.
Great.
Let me also say this.
Yeah.
I mean, Debbie, thank you so much. It's so amazing to have you. I mean, your insights are amazing. And I mean, she has us 5 minutes, so we can just take a few more questions. We are going to be running off exactly in about 8 minutes, and the whole idea is just to let more people put in their questions. But I'll say this: that a whole lot of all your questions is going to be answered during the class. If you have questions, we encourage people to register. We see that people are registering already. Don't make this investment something into yourself. Some of you will register for days. You're not even an HR person. It will help you shape a lot of things, and it will help you help other people. It will even help you as you navigate. So we want to really encourage that. So you can please go ahead and take a few more questions, and we're going to round off in exactly 7 minutes. And also, if you want people to connect with you, you have any questions, you can drop your number, or if you want the team in Luminous to reach out to you, you can drop your message or drop a number. We'll reach out to you, or reach out to you through us through our phone number. Okay. Yeah, please. So again, Debbie, I want to say thank you so much. Thank you, and
Thank
everyone
you.
that has attended. Thank you so much.
Okay. I'm just looking through the chat to see one more question for Debbie before she can take before she leaves us. Okay. Seems more like an email question.
You can go ahead and ask it.
Okay, what would you advise your management team as a HR manager if some part of the workforce is strongly considering joining a union? The
Hmm.
organization is currently not unionized.
Okay, so I'm going to answer that question very carefully. There's no law. In fact, the law strongly frowns against you stopping a union movement. Are you getting what I'm saying? Every employee has the right to be unionized as part of the human rights and employment rights of every employee. And so if they are beginning to make a move, I've been in organizations that we were strategic about it. I might not be able to provide the answer to you openly here. You can reach out to me, but it is begging for something. There is a deeper problem that needs to be addressed. What is the benefit of unionization? Protection, fundamentally, seniority, better pay. If the organization is not unionized and they are clamoring for it, you need to look into your systems. You need to look into your data. What is happening? What are they dissatisfied about? What do they think that they will get in the union that they are not getting now, and they are sure they'll get in the union? So, because if those things are addressed strategically, your union drive will reduce. Because at the end of the day, don't forget that people pay union dues. Right? It's not free. But if people feel their job is not protected, if you feel that they are treated unfairly, there's no process. If people feel that one day anything can just happen, why should they not join the union? So you want to go back and look at all of this factor, but you need to, of course, you can reach out to me and let's talk, because the way you also go to your management must be strategic. You must not be seen as a weak person just coming to report something. You have to go with data, you have to go with perspective and a position, and you go from there. I hope I answered your question.
Thank you, Mole. Hey, any other question?
Somebody dropped something. There's a question. I have an employee.
Okay, I have an employee that abandoned with no call, no show. How much time do we give the employee before we can terminate the employee? And will he qualify for vacation pay in that case?
Well, like Debbie has said, abandonment is abandonment. It's just that there has to be a process. No show, no call. I mean, what I do in no show, no call situation, we would, of course, it would have been clear that they're violating something. They would have elapsed that time, and I send letters, right? Apart from managers and supervisors sending emails, I send nothing minimum 3 letters, right? Minimum 3 letters. And they are not online, sorry, they're not emails alone. We send by email, we mail it to their last registered home address. And I make sure that what I use is registration so that somebody can acknowledge it. You understand? So you have to follow that procedure, because anything could have happened. Don't forget duty to inquire. Anything could have happened. So you don't want to be that person that just terminate like that. You want to follow due diligence and due process.
Let me add to that very quickly before I leave.
Please.
like Imola said, you would write letters. What if the person is not in the country? So I had a case of someone who went back to Africa. I won't mention the country. Who
Yeah.
went back to Africa, did not take leave, did not do anything, and just left. Now we can't send letters to Africa, obviously. So they called and of course got a voicemail. They emailed. He responded to one email in about 3 months to say, I'm not feeling fine. Somebody died, I'm not coming. So it's not really a function of time. It's more of a function of what steps did you do and how well can you prove that you tried to look for this person. If the person is completely not communicating at all, 3 letters, one email, a phone call or two recorded is enough. And then you treat that person like you're not even terminating at that point. You're
Yeah.
treating that person as resigned. They're two different things. So at that time, I'm not going to give you a termination letter. I am going to say, I am accepting your resignation because your abandonment is a form of resignation. And there's a question about whether or not you pay vacation pay. If somebody resigns, do you pay vacation pay? The answer is yes, then you do that. Calculate whatever the outstanding is, pay that
Yeah.
off, and let it go. What you will not pay is notice. They're two different things. Because if you terminate, you are triggering that clause to pay them a notice, even if it's on employment standards. But if you're treating them as resigned, you are not going to have to pay them notice. I'm not the one who said you should go. You're the one who stopped coming. I am going to accept your resignation because you have abandoned your position. If you're entitled to vacation pay, I would calculate your vacation pay, treat you as resigned, end your package, and we're done.
Thank you, Debbie. And I think it also speaks to the culture of the organization as well, right? Like someone had put into the chat, having, the opportunity for or a workplace where people feel free to speak up. Like you should be able to talk to your manager and say you need to go, travel wherever for a holiday or vacation. And maybe if they don't approve because you don't have vacation time, then you can use unpaid time, right? So it's really all about communication. I feel like if we have a great workplace culture, some of these issues won't even spiral that far in the first place. Well, just something to note as HR professionals, maybe some things that we can start to do in our organization to have a better workplace culture creates psychological safety, so we don't have to deal with so much of these issues so often. So I would say we've come to the end of today's webinar. Thank you again, Debbie and Imole. It was really insightful to listen to this conversation, and just the opportunity to even moderate this chat was also interesting and exciting for me as well. Thank you to everyone who participated, who had questions, who put an emoji into the chat. Thank you for staying with us up till this time. And for those of you who have gone ahead to enroll for the course, I'm very sure that you will have a great return on the investment that you're making. So thank you again. Debbie has said you can connect with her on LinkedIn if you want to, and Imole as well. You can connect with him. So thank you everyone for your time today. Hope you have a wonderful Saturday and a great weekend.
Thank you so much. We can drop our LinkedIn handle. It's also a good way to network with people, other professionals. So I'm going to drop mine. Unfortunately, I'm not able to accept people again. LinkedIn has restricted me. I have over 30,000 followers. But you can
Whoa.
please send a message. If you follow me and send a message, I'll say it. Once again, we're very grateful to have Debbie, our wonderful lawyer, to be one of to speak in this session, and of course you, Adriel. It's amazing to
Thank
have
you.
you, the lawyer
Thank
and
you.
the HR,
Thank
and
you.
yes, and to everyone that joined. Thank you so much to my team, Ify, Barbara. Thank you so much, Toby. And Adriel. You guys are amazing, and all the
Yeah.
wonderful
Thank
people
you.
that joined. And I mean, I can see quite a number of good friends that came in. So please register. Once you register, the team are going to be communicating with you. We're going to be sending you emails and updating you. Of course, you're going to join a community, and every information that you have, every question you have, will be answered. It's always a very powerfully interactive session. So, and then it's practical. So as much as possible, register. For some of you here, what you need to do is to tell a friend. What you need to do to tell a friend who is an HR person or who is even trying to get a job in HR. Kels, you're part of the team too. Thank you. Thank you very much. So for